The inclusion of sex as a basis for protected status in Title VII of the Civil Rights Act of 1964 has led to additional areas of legal protection, and a number of laws and regulations now address discrimination based on sex and gender. Sexism or gender discrimination is prejudice or discrimination based on a person's sex or gender. The Pregnancy Discrimination Act of 1978 amended Title VII to require that employers treat maternity leave as the same as other personal or medical leaves. Courts have generally ruled that PDA requires employers to treat pregnant employees the same as those who are not pregnant. Closely related to the PDA is the Family Medical Leave Act, or FMLA, of 1993. The FMLA requires that qualified individuals are given up to 12 weeks of unpaid family leave, and also requires that those taking family leave be allowed to return to their jobs. The FMLA applies to both men and women. The ADA has expanded the definition of disability to include less permanent and serious physical and mental issues, which can be interpreted to cover pregnancies. The Equal Pay Act of 1963 requires employers to pay similar wage rates for similar work without regard for gender. A common core of tasks must be similar to justify similar wages. Tasks performed only intermittently and infrequently do not make jobs different enough to justify different wages. Differences in pay between men and women in the same jobs are permitted because of differences in seniority, in performance, in quantity or quality of production, and factors other than sex, such as skill, effort, or working conditions. In response to a procedural issue in pursuit of fair pay claims, Congress enacted the LILLY-LEDBETTER Fair Pay Act in 2009. This law eliminates the statute of limitation for employees who file pay discrimination claims under the Equal Pay Act. Each paycheck is essentially considered a new act of discrimination. Lawmakers recognize that because pay information is often secret, it might take months or even years for an employee to discover the inequity. The successful plaintiff can recover up to 2 years of back pay. Pay equity involves the idea that pay for jobs requiring comparable levels of knowledge, skill, and ability should be similar, even if actual duties differ significantly. Employers can take some steps to reduce pay inequities, including the following. For the most accurate overall picture, include all benefits and other items that are part of pay to calculate total compensation. Make sure that people know how the organization's pay practices work. Base pay on the values of jobs and performance. Benchmark against local and national markets so that pay structures are competitive. And conduct frequent audits to ensure that pay is fair internally and that there are no gender-based inequities. While there's no federal law prohibiting discrimination on the basis of sexual orientation, 18 states and the District of Columbia have passed laws to protect applicants and employees from such discrimination. In addition, various court decisions prohibit same-sex sexual harassment in the workplace. Sex discrimination based on stereotypical gender attributes about appropriate and inappropriate mannerisms, appearance, and conduct is also inappropriate. An issue that some employers have faced is that of individuals who have had or are undergoing gender transition surgery and therapy. Federal court cases and the EEOC have ruled that sex discrimination under Title VII applies to a person's gender at birth. Thus, it does not apply to the new gender of those who've had sex transformation operations. However, managers and employees should be tolerant of such situations and show respect for individuals undergoing these procedures by making the right accommodations when needed. The influx of women into the workforce has had major social, economic, and organizational consequences. In particular, the growing number of women has led to more sex and discrimination issues related to jobs and careers.